Hello, everybody. Martin Radner here from Radner Law Group, bringing you trial analysis on the YNW Melly trial. We had closing arguments that completed on Thursday. Now the jury is deliberating. We don't know when there's going to be a verdict. We do know that the jury did ask some questions. They wanted the testimony read back to them. So we will see when the deliberations finish and they render a verdict in this case. So could be soon, could be before this video even comes out, and it could be in another 3 weeks. Who knows? There's nothing pressuring the jury to have a verdict sooner rather than later. They have plenty of time, plenty of evidence to go through if they so choose. And let's jump into the defense's closing arguments. But before we do, please like and subscribe to this channel. We do need this channel to continue growing in order to continue bringing you this trial analysis. So please like and subscribe if you haven't already. So let's jump into the defense's closing arguments. So we're going to start off with the defense's closing arguments with how the prosecution, Christine Bradley, finished her closing argument. Remember, she gets 2 times. Since she's the prosecutor, she has the burden of proof, so she gets to give a closing argument, then the defense gets to give a closing argument, and then she gets to rebut some of the arguments that the defense made. So how she finished her closing arguments was that even if the jury decides that Melly was not the one to ultimately pull the trigger, but if he had some sort of encouragement to, and you decide that Cortland Henry, for example, was the one who pulled the trigger. Let's say that's what you decide. And that's one of the defense's theories in this case, that perhaps Cortland Henry was the one that committed the murder. But if you find that there's something called a principle, that if you encouraged and supported and helped that person commit the crime, then you get the same penalty. So she's saying at the end of the day, look, even if you don't buy my story and you buy the defense's argument that maybe the Cortland Henry was one that committed this crime, since it's, Melly, it's very possible that he was helped and supported and encouraged him to commit this crime. So you have to find anyway that he is guilty. So that's how she finished her closing arguments, and that was a very strong point. But then the defense got up and used that exactly against her. And look what he said.
Is he a principal or a shooter? That's what the state addressed you folks just a few moments ago before you went to lunch. And the reason they said that is because they don't even know. Otherwise, they would select either him being a principal or the one who caused the death of Williams and Thomas. It's that simple.
So saying that, look, they don't even know what they're talking about. They don't even know, they can't even point the finger themselves at Melly for committing this crime. They can't even say that he was the one that pulled the trigger. So that should tell you something about this investigation, something about their own doubt that they don't know themselves. If they knew themselves, if they were so convinced that he actually pulled the trigger, why would they even bring up this idea that maybe there's a principal, maybe he was a principal in this crime, and maybe you should convict him anyway? I mean, he could have made a very, very big deal about that. I mean, he did do a good job, but he could have said, look, they don't even know whether he shot these 2 individuals, or else they wouldn't have even brought up the point of the principal. So very strong point. Then he also talks about that he is not required as a defense attorney, as the defendant, you're not required to bring any testimony. And that's very important because the jury sitting there, they just heard from 26 different witnesses from the prosecution side, and now the defense only calls 1 witness. So it looks like, hey, you got 26 against 1. That doesn't look so good. But so therefore, the defense attorney has to remind the jury that really they don't have the burden of doing anything. They just have to show up. And he keeps reiterating this throughout his closing arguments because it's a very important point that the jury has to understand, that they can just show up and they don't have to say a word. They don't have to do any cross-examination. They have to do a closing argument. They have to do nothing. And the prosecution still has to prove their case beyond a reasonable doubt. So he has to make that point, and he does do that very well, as we see.
The judge goes on to tell you, and it's in your packet of jury instructions, that the defendant, Melly, is not required to present any evidence or prove anything.
Now, he also apologizes to the jury. Now, because he says that, maybe you didn't like some of my mannerisms, maybe I didn't behave myself. And to be honest, looking at some of his mannerisms as he's conducting cross-examination kind of rubbed me the wrong way. His pacing, his facial expressions, his mannerisms was kind of getting on my nerves a little bit. The prosecution was, Christine Bradley was basically just standing there. She was, directing the witnesses, crossing the witnesses, but she wasn't like pacing around and doing these, faces and getting all heated up, so she understands it, and therefore he has to tell the jury, look, you may not like that about me, but please don't use that against my client. So see what he says here.
Remembering, we don't have to do a thing. All we have to do is show up and behave. Now, I don't know if I behaved totally correct during the course of this trial. So, on behalf of us, let me apologize if I have or we have offended any of you. And I would ask you, I would plead with you, if I or any of the other individuals have done anything to irritate you, don't take it out on this young man. Still hold the burden of proof to this table.
Now, another point that he makes, which is a very, very strong point that he has to make, is that there's been no eyewitnesses. Now, the jury is given instructions that there's two types of evidence. There's direct evidence and there's circumstantial evidence. People think that circumstantial evidence is not really considered evidence. That's incorrect. Circumstantial evidence is actually evidence, and that's what this entire case is built on. But it's still not as strong as direct evidence. So therefore, the defense attorney wants to point out that there is no direct evidence that Melly actually shot the gun. There's been no eyewitnesses.
Number three, that there's absolutely no eyewitness that will implicate this young man to this crime, these crimes.
Okay, then he gets into Sergeant Williams. Sergeant Williams testified that the city of Marmor lacked training. Take a look.
And the last one that we absolutely agree with, and they admit it, the Miramar Police Department lacks the training. Those aren't my words. That was Miss Bradley just an hour ago saying. Not only did Miss Bradley say that, but Sergeant Williams also said they lacked the training and one of the worst investigations. That's why I pushed aside their reports.
So that's very strong. Sergeant Williams is saying that, look, I mean, the city of Marmor didn't have the training to do part of this investigation. Now, again, you know, as Christine Bradley said, and then she's going to point out in her rebuttal, he's not saying that they had no training to do any investigation. He was just saying that certain parts of their investigation they're not trained in, and that's why he was brought in to, to fill that gap, so to say. But still, the defense is making a big point about it, saying, look, the city of Marmor just lacks, generally the training to do an investigation like this. And again, a very strong point that he brings out was that Jeep was searched for 15 hours after this accident, 15 hours after this murder. And still, when Sergeant Williams came to search that car 3 years later, he still found things that they missed. So that's such a strong point to the jury, saying, look, they searched this car for 15 hours. They're so incompetent that they still miss things. Even though they searched that Jeep for 15 hours, they still weren't able to find certain things that Sergeant Williams did find.
Well, before I talk about the first witness, I want you to remember one thing. On October 26th, that day of the shooting, we learned immediately that Jeep was taken to a secure area. And it was searched for over 15 hours by 2 crime scene technicians. And you heard how they pulled out the evidence. They got some foam, some projectiles, I think a can, everything, and photographed the vehicle. Now, why is that important? Because that vehicle was searched. Are you okay? You want to take a break? That vehicle was searched again months later. But it didn't stop there. Because about 3 years later, miraculously, even though it was searched for hours by crime scene technicians, Sergeant Williams comes into the scene at the request of the state of Florida, this particular prosecutor right here, and miraculously he finds additional evidence, 2 projectiles and a bloodstain that obviously everyone else missed.
So that, again, shows that the city of Marmor lacks the training to do a proper investigation into a murder case. He also points out that there's no search warrants for Cortland Henry, and there's a lot of search warrants that could have been written or they could have tried to get all the video, all the surveillance from all the different businesses, going down those streets and everything like that. So he does bring out that point a lot also throughout his closing arguments. He speaks about George Bello. Now, George Bello was an expert on the guns. And he says that, look, George Bello said you can't tell the distance of where the gun was until you have the gun. If you have the actual gun, then you can actually see and tell where the distances were from the shooter as opposed to the person who was shot. And they're trying to tell you, that Sergeant Williams is trying to tell you that he can tell where the shooter was. So that's a contradiction between George Bello saying you can't, and he's the expert here, and Sergeant Williams saying, oh, yeah, sure, I can tell you where the shooter was. So again, very strong point saying that, look, there's a contradiction here between Sergeant Williams and George Bello, who is really the expert here.
That can you tell or determine the distance between the shooter and the victim? Can you tell us that with all your experience? And what does he say? I can't do it unless I have the weapon. Unless I have the ammunition, because ammunition, the weight of ammunition, could change the distance, and you have to have the weapon in order to do that. He cannot even tell us if it was one gun, two guns, or more. Then he totally contradicts all the testimony of Sergeant Williams, who comes in here 4 and 5 years later and says, I can tell you where shooter one was, and I can tell you who the shooter is.
Now, also, George Bello said that you have to consider the environment. And Sergeant Williams, who came 3 years later, obviously didn't consider the environment when he gave his opinion. So, again, another contradiction between Sergeant Williams and George Bello. He also said that Brendan Collins, the FBI agent who tracks phones for a living, he does this nationally, does this internationally, this is his expertise, and he said that you cannot determine the precise location of the phone. Now, again, Christine Bradley kind of conceded this point in her closing argument. She said, yeah, you don't know exactly where they are, but they can give you within a range. It's not going to be like you're 10 miles away from where they think you are. So, but again, the defense attorney has to use whatever evidence he has, and at the end of the day, Brendan Collins did say, look, you can't determine the precise location, so he wants to instill that idea into the jury's minds that you can't for sure determine the precise location of the phones. Now, he also says he doesn't rely on the phone records to determine the location. He has a whole different way of doing it. This is Brendan Collins' testimony, and Sergeant Williams did, and Detective Moretti did rely on the cell phone data to track location. So that was also somewhat of a contradiction between the purported expert Brendan Collins and Sergeant Williams. Now, the response to that was, well, he said that you could use other ways. He just personally, what Brendan Collins was saying is that he personally doesn't use that way. He wasn't discrediting it. That was kind of Christine Bradley's rebuttal to that. Like he wasn't saying that it's impossible, but it's just saying that he doesn't personally rely on that. Okay, so then, see, he wanted to point out a lot of these contradictions between Sergeant Williams and the other experts that testified in this case. So now he went on to Felicia Holmes, and Felicia Holmes is also a very strong point to be made on the closing arguments, because at the end of the day, there has been evidence that Detective Moretti threatened potential witnesses in this case. He threatened her, he threatened her daughter, he also threatened other people that they may not see their kids or that they may get deported. And this is coercion. This is like you're scaring these witnesses that they must testify, and then they're going to feel like they have to testify with what you want so that they don't get locked up themselves.
The next witness I think you need to pay particular attention to and really get a flavor of what this case is all about is Felicia Holmes. Felicia Holmes tells you that the Miramar detectives, Moretti and his group, threatened her, bullied her daughter, told potential witnesses they were going to prison, told witnesses that they may never see their children again, told a witness that he was going to be deported even though he's been in this country since 5 years old. He was going to be deported to Haiti where they won't feed you. The place is, with all due respect, and excuse my language, but it was his language that he used, shit.
So that's a very, very strong point that the defense made in their closing arguments, and it's a very strong point that the jury can be thinking, hey, who was threatened into saying things that they didn't really want to say or that they didn't really remember, in order to just kind of save themselves, save their own skins. So that was also another important part. He also says, then he gets to what his theory of the case is. He says that, as he mentioned in the opening statement, actually the other defense attorney mentioned this in the opening statement, that his theory is that Detective Moretti wanted to become a star. And once he realized that Melly was an up-and-coming star, he wanted to prosecute him, and he had tunnel vision, and he did this. He had tunnel vision only to look at Melly and ignore everything else that was going on in the case.
When Moretti got that surveillance tape and realized this young man, this little kid, excuse me for calling him a kid, he was 19 at the time, was a rap star, making more money than he'll ever see in his entire career at 19. He got tunnel vision. And he wanted to nail this kid. And what better way to move up the ranks, get some publicity, is to arrest a star.
I told you, if you remember what I said about the opening statements, you can take a look at what I said about the opening statements. But I think that that's a mistake. I think that it's a mistake to give the jury a theory like this. It smells of conspiracy. There's a lot of conspiracy theorists that people don't appreciate, doesn't always resonate with the jury, that there's just some major conspiracy, especially Detective Moretti, who served and he's been doing this job for 20 plus years. All of a sudden he wants to get famous. It's just a hard sell. And to lock yourselves into that theory is very dangerous, because if the jury doesn't buy that theory, then they may just throw out your whole defense. If you say, look, the investigation here was obviously very inappropriate, they didn't do a lot of things that they should have done, and it was just sloppy and it was botched, and look, Sergeant Williams had all these things to say about it, and they found things in the car that was already searched for 15 hours, and you poke holes in all the different areas of investigation in this case, then just leave it at that. Tell the jury, look, this investigation was obviously very botched. What are the possibilities? Why did they do this? Well, it could be Detective Moretti wants to prosecute a star. It could be other things. It could be they're just completely incompetent, which would give you the same result. So why would you lock yourselves in to this theory of the case? And if the jury doesn't buy it, then they could just say, well, this is your theory of the case. We don't buy it, and therefore we're going to side with the prosecution's case. So I think it was very dangerous. And I think it was very interesting that they kind of locked themselves into that theory of the case. Then he spoke about Kirk Rhodes, who was the DNA expert, and his main part about Detective Rhodes was that he didn't even do his investigation until a few days before the trial. Take a look. The fourth witness was Kirk Rhodes, the DNA expert. Now, why is he important?
Because while we were picking a jury in April and we were off in May, this prosecutor asked him to go back to the car and check some DNA. Now, why would you do that? The case, according to Moretti, is closed as soon as this young man is arrested. Now, it sounds terrible. It sounds like, oh, wow, they didn't even think about doing anything about this case, getting the real evidence in this case until it's a few days before trial. While he's sitting in jail, he's sitting in prison, Melly's sitting in prison for all this time, and they didn't even have a complete investigation yet. That looks very bad against the prosecution, looks very bad against the detectives. However, was Christine Bradley's response to this, and this is what she mentioned in her closing arguments as well. She mentioned this already, and then she's going to rebut it as well. She says, no. Those swabs were taken already. And remember, we went through a pandemic during this time, right? The murder was committed in 2018. We went through a pandemic. There wasn't like you're just going to walk into the courtroom when everything's shut and start doing all of your testing on these swabs. So her point is that, look, the swabs, all the investigation was complete. We just had to get the final results on this. And the final results, we have trial coming up. And of course, there's, there could have been other murder cases that they're working on, a lot of other cases that needed more attention, that needed quicker attention. And that's why they didn't, bother testing it until before trial. And, they eventually, well, now the trial's coming up. So they, they just have to test it. But of course, her point was that they didn't actually swab it before, they actually, right before trial, they swabbed it already, after the murder was committed. So, that was her response to that. Then he also mentions that this gang expert didn't get involved only until 2022, because then they realized, oh, there could be a death penalty here. That's kind of what they're insinuating here, that, oh, there's, now that they're realizing what this trial can bring, then they bring in this gang expert in 2022. Okay, and then his response to this gang, right? So you got all these signs that Melly's doing, and they're all in evidence, and you got these text messages that are talking about the gang. So their response to that is, look,
rap culture is connected with gangs, whether you like it or not. The gangs are attracted to the rappers, and it's the way that you promote your music is through rap. So first, rap culture is connected to the gangs. Take a look.
In the rap culture, whether you want to accept it or not, gangs are attracted to it.
And then this is, it promotes your music, just like Snoop Dogg, just like any of these rappers, that they kind of do these symbols during their music, is just because they know that the gangs are into the rap, and therefore they want to grow their business, so to say. So therefore they do this, but it doesn't really necessarily mean that they're involved in a gang.
And he does that because he realizes it promotes his music.
What's the response to that? Well, the response to that from Christine Bradley is she said this in her closing argument as well, and she said, well, that's all good and dandy when you're putting out a public video, but what about your private text messages between you and your private friends? Would you start, dropping signs? Would you start, talking in a way that shows that you're part of this gang? Why would you do that? If it's all about the music, it's all about artistic expression, then you should just do it in the public, and your public videos, and not privately. So that was the response to that, and the jury can be thinking, okay, why would he do it in their private conversations? Now he also brings some other theories that this is the defense attorney. He also brings some other theories in his closing arguments. He says, well, there are certain text messages that he got from gang members saying that if he doesn't respond, and he doesn't, I guess, acknowledge them, and I guess have some sort of conversation with them, have some sort of relationship with them, then they're going to put him on the plate, which he says means they're obviously going to murder him. That's a death threat. And he said that Detective Melly never investigated that. Why wouldn't he investigate that, that threat?
This is the great investigation. But he also refers to some text messages where those individuals that are in fact associated with the gang text him and he's not responding. And to the point of not responding, they say they're going to put you on the plate. Now that's not for dinner. That's not for breakfast. We learned what that means. If you don't start responding to us, we're going to have you killed. What the heck's going on? Why wouldn't you investigate this?
Now also, he talks about the medical examiner. So he says this is very important because the jury says, I do want you to pay attention to the medical examiner. The medical examiner said that the wounds to the head came first. But he said, but if you notice, that Sergeant Williams said that the wound to his hand came first, because the point that Sergeant Williams was saying was that this was in defense. He had no idea that he was getting shot, and he kind of put up his hands, and that's why there was some wounds on his thumbs, because showing that he was surprised that he got shot. So the defense is essentially saying, well, the medical examiner said that the first bullet came in and hit him in the head, and now you have Sergeant Williams saying that no, the wound to his hand came first because he was putting up his hands.
I want you to pay particular attention to Dr. McDougall and Dr. Saunders, because those two doctors, one being the chief medical examiner of Broward County, the other one an associate medical examiner, I think now employed in West Palm Beach, say to you that the first shot to Williams and Thomas were fatal, deadly. Why is that important? Because according to Sergeant Williams, Thomas's injury to his hand came first.
But I think the response to that, and I don't think that the prosecution mentioned this, but I think they could have certainly, is that that he didn't necessarily say that the wound to his thumb came first. It could be there was the thumb behind his head that eventually got hit, and also it could be that the medical examiner was not talking about these superficial wounds to a thumb. She was just talking about the actual fatal shots, the shots to the lungs, the shots to the head, and which ones came first. That's when she was able to tell which one came first, and not specifically any other wound on the rest of his body. So I mean that could have been rebutted that way. So his summation and kind of what he was saying with all these contradictions to Sergeant Williams' testimony. So what he was saying was that you should just take Sergeant Williams' testimony and just throw it out the window, just completely ignore Sergeant Williams' testimony. And again, you're asking the jury to do a lot. You know, when you can ask the jury to do a little, ask them to do a little. Don't ask them to do a lot. When you're asking them, let's say, to swallow your theory of the case that this was all one big conspiracy, that's asking the jury to do a lot. If you don't have to do that, don't do it. So here, you're asking the jury to just completely discount and discredit Sergeant Williams' entire testimony. I think that a little stronger would have been a little more palatable to the jury would be to say, look, we've got so many problems with Sergeant Williams' testimony. I don't know which parts are true, which parts are not true. If you can figure it out for yourself, that's great. But we obviously have some serious problems with his testimony. And you know what that does? That creates reasonable doubt. So instead of just saying, well, just throw the whole thing out, ignore him, he's a complete liar, he doesn't know what he's talking about, you're asking the jury to do a lot. So I think he should have just been a little bit easier for the jury to say, look, there's a lot of questions. We don't know what's going on. That's certainly reasonable doubt. Okay, so that's just another point. He goes on and he talks about Travian Glass. And what is Travian Glass' motive to lie here? Travian Glass was the one that said that Melly was not in that Mitsubishi car, which means that's essentially what their entire case is. I mean, well, they really have two options. Either this was a drive-by, which is completely debunked by the evidence, or that Melly actually wasn't in the car at all. And that was essentially what their defense is, that he wasn't even in the car, he switched cars. But Travian Glass said he was in the Mitsubishi. He said he wasn't in the car. Melly was not in the car. So the defense has to discredit Travian Glass. So how are they going to do that? And he did it very effectively. He said, well, look, Travian Glass has 2 felonies on his record right now. He can be thrown into prison. You know, you're a felony. You have felonies that you're convicted of or you're being charged with. You can be very easily thrown into jail. Well, wouldn't you want to cooperate with the state? Who has the power to put him behind bars? The state does. So if the state has the power to put, don't you want to cooperate with the state and try to help them with their case against this person? And then maybe there's some sort of side deal with you that you will be able to, you know, have a lighter sentence, have a slap on the wrist. So that's Travian Glass's incentive and his motive to not be honest. And that's kind of what he was saying, that even though you have this discrepancy between Travian Glass and Adrian Davis event, whether Melly actually switched cars, but he's saying you should completely discredit Travian Glass.
There's only one person who can put him back in jail. And that's the state of Florida, whether it be through the state attorney's office or the police department. And he miraculously is the only witness that says no one got into the red Mitsubishi from the recording studio. But he doesn't tell you how he gets into Melly's house.
He also said, well, the prosecution said, well, what reason was there for the Jeep to stop? Remember, it was only a half-hour drive from the studio to their house, so why would you have to stop? You were in the, Now, they didn't mention this, but he said, well, maybe he needs to use the restroom. Maybe he needs to use the bathroom. And they just have to stop on the side of the road. That takes, 5 seconds, 10 seconds, 30 seconds, and then they're back in the road. So, the fact that the prosecution is saying, that he didn't mention this, but this is what was an implication, is that, well, the fact that the prosecution is saying, well, it's 30 minutes from the studio to his house, and it took them 30 minutes, and it's 30 miles away, which averages 60 miles per hour. Well, that would suggest that they didn't make any stops. Well, a stop for 30 seconds is not going to throw off the whole ETA there. So, it's very possible, it's plausible what he's saying is that maybe they stopped in the bathroom, and when he stopped at the bathroom, he left his phone in the car.
The reason was because he needed a bathroom break, just like you and I did when I raised my hand or stand up. And at 3 o'clock in the morning, 4 o'clock in the morning, if he needed a bathroom break, in the dark highway, and you saw him carry it in his hand, he'd leave it on the seat of the car. And we know that the car sped off because there was another car waiting.
So that was his suggestion for what happened. Then he moved on to another possible suspect, which was Jameson Francois. But Jameson Francois was Melly's manager, and he was the one that controlled all of Melly's money, essentially. And the evidence is that he just got $16 million in his account to go and distribute. And again, we don't know exactly how much of that money was going towards Melly or not. He's a manager. He probably works for a number of different people. But the suggestion by the defense attorney was that that was a motive in itself. He's got this $16 million. Let's assume that that $16 million is for Melly. And he's like, hey, look, if I can just knock off Melly, I'll just keep the money myself. So he's kind of suggesting that Jameson Francois could also be a suspect.
Jameson Francois with the missing guns. He's the manager who had, I think, $16 million in his account. If anyone had a motive in this case, it would be Jameson Francois, possibly. I don't know.
Prosecution said, it's so unlikely that Jameson Francois was involved. His phone wasn't there, and he was at home, and there's all these alibis and there's all this evidence that points to him not being involved. In fact, the next day he went with Melly to, that Pembroke Road to look. What the prosecution's suggestion was that they went to go clean up the evidence of what happened. So, the defense has to use what they can and try to just throw all these theories at the wall and see maybe it'll stick with one of the jurists, and maybe that will eventually win the case for them. So, they brought up that motive also. Now, before he finishes with two more points. One of the points is that Adrian Davis and the way that he brings this out, I thought was very, very effective. He said, look, the prosecution brought 26 witnesses. They have 26 witnesses, and they spent all this time, all weeks and hours of your time, trying to present to you the case. But why didn't they call Adrian Davis? You want to give this jury, you want to give them all the information, give them all the evidence. You want to be forthcoming. You want to be transparent as a prosecution. You're not here because you're trying to lock anybody up unfairly. So why don't you present the whole case? Why don't you call Adrian Davis? And that's a very strong point. Why didn't they call Adrian Davis? Just because Adrian Davis is going to testify against them? Well, but you're trying to be fair. You're trying to be honest. So then put all the evidence in front of the jury and let the jury decide. So that's such a compelling argument. It's so strong that it looks like the prosecution and the detectives in this case are trying to hide information from the jury. And when you're painting your opposing counsel in a way that shows that they're not being forthcoming, they're not being honest, that could make the jury think, hey, they're not being honest, and therefore, what else are they hiding from us? And that can start making them think that maybe there's some other theories over here, and maybe we're just not getting the full picture, and that's why we cannot convict Melly. So that was a very ingenious way for him to bring it up about Adrian Davis. Not just mention Adrian Davis, contradicted their testimony, but also kind of put it on the prosecution. Why didn't you call Adrian Davis?
And then the state rests. They say, folks, we've presented you all the evidence. Well, that wasn't true, because we had to call Adrian Davis. And you learned that Adrian Davis showed up in the state attorney's office and gave a sworn statement. They never told you this. We did. We don't have to do any of this. And Adrian Davis said, I told you. He got in the car. How do I know that? Because I was woken up when someone was crawling in the back seat. How do I know that? When we got to Melly's house, he's the one who had to open the door. Because only he and Cortland Henry have the key to his house. Why do we have to do that? Why did they conceal that from you? Why did they hide that from you?
Adrian Davis said that he was not in the car. Melly was absolutely not in the car. Melly, that was just the opposite. Adrian Davis said he wasn't in the car, but Adrian Davis said absolutely he was in the car. And in fact, they needed his key to get into the car, get into the house. Remember, Adrian Davis said there's no other way to get in the house. There's only two people that had the key, Cortland Henry and Melly, and they were both in the same car. And I guess, Mitsubishi, maybe they're driving faster, or maybe the other car wanted to stop off somewhere, and therefore they needed a way to get into the car and get into the house, and that was by picking up Melly. So that was the suggestion by the defense, what was going on with picking up Melly. First they're saying, first they were saying that he stopped off to go to the bathroom, and then the defense is saying, well, maybe they needed him to get into the car, get into the house, maybe both, but again, both theories kind of just throwing out there at the jury, let the jury kind of figure out all these pieces and put them all together. So that was what they said about Adrian Davis. And then he also said that, what about that video shoot the next day? Now remember, his question also, the defense brought up about Travian Glass, that Travian Glass, how is he supposed to get into the house? If Travian Glass's testimony is true, aside from the fact that he's this felon and that he just wants to cooperate with the state so that they'll be nice to him, but how is he supposed to get into the house? How does that make sense of Travian Glass's story that Melly or Cortland Henry weren't with him? Well, number one, they're right behind them, so they could be coming in 2 seconds. They can wait for him. That's number one. And number two is that what the prosecution brought up in rebuttal, which is just so strong. The prosecution brought up and showed text messages clearly indicating that Adrian Davis had a key to the house. So that's very strong to rebut that Adrian Davis needed Melly somehow to get into the car. So that also kind of shows that Adrian Davis wasn't being honest, and that's a very strong point from the prosecution. Okay, so the final point that the defense made in their closing arguments was that he went to the video shoot the next day, right? Everyone remembers that video that they had of Melly the next day after his two best friends were murdered, and what Melly is saying is that wasn't even him. He was so sad and he was so distraught and broken from this, and yet a few hours later he's going and producing this music video, and he's happy and he's smiling and looks like he's having a good time. How can you do that if really you're just so distraught that your two best friends just got shot and you had nothing to do with it? So that was one of the arguments that the prosecution makes, and the defense says, well, he was that video cost him, money. And what he kind of said is that we all deal with certain situations where we have to just push through and continue our day and continue our work, even though we're dealing with a death in our family maybe, or dealing with other, hard situations. You still go on and do the best that you can. And that's what he was doing. He was standing to lose a lot of money. And he said, the prosecution said that, some other videos he had no problem, canceling because he wanted to do his hair or whatever. So, why can he cancel this video that's, when his two best friends just died? He said, well, we don't know how much money he would have made on those videos. Maybe those other videos that he missed, was maybe $1,000, $2,000, but this video could have been much more. So maybe he didn't want to, miss this video. So the fact that you see him at that video, being happy and look like he was, being able to operate like normal and not just completely in a stage of being broken because his two friends were just murdered, is not such a strong it's not such a strong indication that he was actually the murderer in this case.
They had no idea what the contract was. They had no idea how much money was involved. They had absolutely no idea. Why? Because there was no investigation. Play this.
So I think the defense, at the end of the day, I think they did a good job. I think he used the evidence, whatever he could, to make the arguments as strong as he could that Melly did not commit the crime. Again, like I said, there's very, very strong evidence that he did do the crime. And there's a lot of holes in the defense's arguments. But at the end of the day, you never know how the jury's going to come back. It could be that they will find some reasonable doubt and they'll acquit him. And at the end of the day, we don't know how the jury's going to come out, but we will see. One last observation that I had was that you don't really see the fact that that this murder was going to help him at all in advancing in the gang. And part of what they, to get the murder, to get the death penalty is you have to show that this murder had some way of affecting your status in the gang. And you don't really see that so much. You see that, yes, he's affiliated with the gang possibly from these text messages and from these videos, but you don't really see so clearly that this, like any text messages that says, if you do this murder, then you'll become X, Y, and Z, or you'll get better status or anything like that. So I think that that also wasn't stressed enough in the defense's argument that, this affiliation with the gang, even if there is one, the murder had nothing to do with that. But again, maybe they didn't want to concede at all that he did the murder at all. But certainly a question in my mind. Okay, so that was my take on the defense's closing arguments. And please like and subscribe to this channel, and we're looking forward to bringing you continued trial analysis.